Well, welcome. Why don't you tell us who you are and where you serve?
I'm David Noce. I'm a United States Magistrate Judge in the Eastern District of Missouri in St. Louis, headquartered in St. Louis, and have been a magistrate judge since October 1, 1976, and have been reappointed a number of times after that.
So I've been here for 28 years and always have felt pretty senior, but 1976, I was still in law school. How did you get to be appointed at such an early stage, and how many times have you been reappointed?
Well, I was a law clerk for two of the district judges, and one I feel very lucky and fortunate to have had the opportunities that I've had. I came out of the Army as a legal advisor. I was a quartermaster corps officer and was assigned to a command in St. Louis under the control and jurisdiction of the quartermaster branch of the Army. And when the Vietnam War was ending, a position came open. Actually, I just inquired of a friend of mine, a law classmate of mine, if she knew about any openings, legal openings in St. Louis, and she asked me whether or not I thought I would like to clerk because she was leaving her position, and I said I would be honored to do that. And so her judge, District Judge Ken Wanglin, appointed me his law clerk. I was with him for about 2 years, and then I was looking for another position when the chief judge asked me to stay on and clerk for a newly appointed district judge, and I did that for 1.5 years. And then after that, I was appointed an assistant United States attorney and prosecuted a number of cases for a relatively short period of time. The district at that time had one magistrate, William S. Bond, and the judiciary added a position, and I applied for it, and I was appointed the second magistrate. We were called magistrates at that time, United States magistrates. I was 32 years of age, recently married, and was very fortunate and to engage in those duties.
So that was in 1976, how many 8-year terms have you served?
I have served 5. I am currently in my 6th 8-year term. And I have been appointed most recently 2 years ago to an 8-year term because now, since I'm over the age of 70, I have to be reapproved for another year shortly before my birth date. And so in order to give me that opportunity, the district judges reappointed me to a 6th 8-year term. Whether or not I serve out those all 8 years is another question, but I'm not quite ready to retire yet, but it is certainly a word in my dictionary.
Okay. And did you ever have any competition in reappointments or issues?
I don't know. Certainly not in the reappointment process. I know there were quite a number of people interested in the appointment the first time I was appointed, but each of the successive times, they did not open it up to applications.
Okay. So tell us a little bit about your experiences before the bench. You mentioned a little bit about your assistant U.S. attorney experience. What other religious, educational, family issues? Tell us about how you came to be a judge.
Well, early on, I planned on becoming a Catholic priest and went through the Catholic grade schools and went into the seminary. I was in the seminary for 4 years of high school, 2 years of college, and then decided that my vocation wasn't there and went to finish up my undergraduate program at St. Louis University. In that course of study at St. Louis U, I took a course in international law from Kurt von Schuschnigg. He was the Chancellor of Austria when Hitler overran Austria, and he and his wife spent the war in a concentration camp. But he taught political science at St. Louis University for a number of years. And so I visited with him, and I asked him, just a comment about being a lawyer in the United States. And he said that there was no other country in the world that held the judicial system in as high an esteem as in the United States. And so that sort of bolstered my idea of going into law school. I graduated from St. Louis University with a history major, political science, English minors, and philosophy minor, and had to do something besides teach history for a living. And I had felt very much interested in going into law. So I did do that. I have to also say I'm the offspring of grandparents, two of whom came from Ireland in 1901 and two of whom came from Italy shortly thereafter. And while I was not the first in my family to go to law school or the first to get a college degree, I will tell you it was a very moving experience when my father's father told me that he was very much appreciative of the fact that I became a lawyer, that he was very proud, and it brought a lot of pride to him personally that I was able to do that. And so that kind of family support was instrumental in giving me, I suppose, I don't know if strength is the right term, but certainly the dedication to getting a good legal education.
Were there other people in your life that supported your candidacy for the magistrate job?
Well, my wife, we were married shortly before, a couple of years before the position was offered, and she, without her support, I certainly could not have stayed in the position as long as I have. Spouses really, and her especially, was very supportive. And our children, although they've only known me as a judge, but hopefully as a loving parent, and family members, I think, were always very supportive. I have a first cousin who went through St. Louis University Law School just a year before I went through the University of Missouri Law School. So he had been a lawyer for a year longer than I, and regularly holds that over my head. But
what about Article 3? Were you ever a candidate for or have opportunities to be considered as a district judge?
Well, 3 times I applied, and the first time I actually made it to a panel. There was myself, Missouri Supreme Court Judge George Gunn, and attorney Gene Hamilton, and the senator at the time, Tom Eagleton, took a while. I think that was Danforth. Took a while. John Danforth took a while to make the decision, and I would tease Judge Gunn, I'm giving him a run for his money. I had become acquainted with him because he was a very good friend of the district judge I had clerked for the second time. He was first appointed. He was selected. Came as no great surprise to me. And then I applied a second time. The process is fairly exhausting. And the second person who was selected was Jean Hamilton. She became a district judge. And then the third time, Catherine Perry became a district judge. I did not have partisan politics in my background. I have absolutely no hesitation for the country looking to the political parties and people who have worked hard in political parties to being selected for Article III positions, if they're good people, intelligent, honest, and very good individuals, because in politics you make a lot of decisions and you work with other people. And I personally believe the Constitution is drawn up so that that's basically where the appointing authority looks for to the president to fill Article III positions. Lightning can strike for other people, and they may be appointed for other reasons. But I stopped applying after three opportunities, and settled back and just enjoyed being a magistrate judge.
So what's the impact been on your family of becoming a magistrate judge?
Well, there are a number of them. I believe that they're all pretty proud of what I've achieved in that respect. I know my children, have an understanding about the work that I do. I've taken them to the courthouse, and it's been a part of their life. They've heard the agents coming into the house on weekends, and we've had 2 golden retrievers who insist at different times, who insisted on vetting each of the people that come into the house. So it has been, I think, substantial, but it's not been negative. The only time it was negative, I've had a couple of threats. There was one threat that the person, and I was acquainted with the person, and I won't go into that anymore, other than to say that because I was a federal judge, I had something to do with the abortion industry. And therefore, that person thought it would be appropriate for me to see my children killed and then to come and kill me. And so there was an investigation and a trial and a conviction. I've never retreated from taking a position of protectiveness for my family. I felt that needed to be done. But that had an impact. Security is an issue, for the family. Not so much for my children, I don't think, but my wife is very sensitive to that.
So who are some of your role models as judges?
Well, the one person who was really instrumental, I think, in my initial appointment, along with the 2 district judges that I had clerked for, was Chief Judge Jim Meredith. He was a big, tall man, and he was John F. Kennedy's manager in Missouri, election manager, and he was a judge's judge. He went, as had a couple of the other district judges, to other districts to preside over trials of other judges. And one anecdote that I tell people about, because in those days, the district judges were looked upon as being somewhat overbearing, but Chief Judge Meredith, a conservative Democrat, referred a prisoner case to me. It was a fellow in the city jail, St. Louis City Jail, who was playing cards on a Friday night with a bunch of other prisoners, and he had a hand, and he slammed his hand down on the table, and he hurt his hand. So he went to the guard and said, "I've hurt my hand." And the fellow said, "Well, they'll look at you tomorrow morning." So Saturday morning comes, and he goes to the fellow and he says, "I've hurt my hand." "Well, they'll look at you this evening." And he kept being passed on until Monday morning. And Monday morning, he finally got to see a doctor, and his hand was x-rayed, and his hand was broken. And so he sued for intentional what's the phrase, intentionally not giving him the medical attention that he should have received in the jail. So the
disregard
right,
medical needs.
exactly. And so the case was referred to me by Judge Meredith. It was my first referral, and I presided over a jury trial. The jury found in favor of the prisoner and awarded him $1,000. And so the case I entered judgment, and that was the end of it, end of the case. So out of courtesy, and I went back to Judge Meredith, and I said, I just want to tell you what the outcome was. And I told him that the prisoner won and got $1,000. And he said, he looked me in the eye, and he said, was it fair? And I said, yes. And he said, next case. So that's one thing I have to say about all of the district judges that I have worked with in St. Louis. There has not been one district judge who intimated what any decision ought to be that I made. And I will say that, backing up a little bit, one of our district judges before he went to the 8th Circuit was William H. Webster, who, upon my appointment, counseled me, knowing the strong personalities of the district judges. He just said, be independent. And I took that advice to heart. And I've had a number of role models as judges, Judge John Nangle, Ken Wanglin, and actually a number of the magistrate judges in our district who have become district judges. They've all been terrific judges and created a culture, I think, that is, really outstanding for the judiciary.
So tell me a little bit more about the friendships and relationships that have supported your service as a magistrate judge.
Well, certainly in the federal judiciary nationally, the colleagues that I've worked with, like yourself, and around the country, the federal magistrate judges are very collegial, very supportive, very friendly, and just a great group of people to be associated with. And I've participated in any number of programs with the association and with the administrative office and the other programs that the system has, and they've all been terrific. And I haven't had a bad experience with one of them at all.
Tell me a little bit about your experience as the 8th Circuit Judicial Council Magistrate Judge Representative. You were the first, I believe.
I believe that's correct. That was my memory. I don't remember anybody being there ahead of me. It was a terrific experience. The 8th Circuit Judicial Council operates at that time operated on a committee basis, and I was included in a lot of the governance and voted with the representatives of the district courts in the 8th Circuit and the circuit judge, and it was a terrific experience. I can remember time after time getting these mailings from the circuit executive about complaints, judicial complaints, and we would all of the members of the council would read them and then indicate to the chief judge what our thoughts were, and then the chief judge would decide whether or not it was to go forward or be dismissed. So it was a terrific experience, and I have to say it was a privilege.
Were there any district court committees that you haven't mentioned yet that you worked on in St. Louis?
Well, I've been on just about every district court committee. I'm currently a member of the Alternative Dispute Resolution Committee, although magistrate judges do not act as mediators, but that committee is made up of a couple of district judges, about a half dozen lawyers, myself, the clerk of court, and we administer the adjunct, I suppose, our certified list of mediators and preside over changes in the rules and regulations for the operation of that program. I have been on the Rules Committee, actually currently on the Rules Committee of the District Court, and been on many of the governance committees.
Are there any other extrajudicial responsibilities that you wish to comment on?
Well, I will highlight, I suppose, my involvement with the District Court's drug court, Project EARN, expanding addicts network system. And for 6+ years, Carol Jackson began it in our district court. She was a district judge and a former magistrate judge whom I have worked with for many years. And we were, I think, the 6th or the 8th district court in the country to establish a drug court program with the probation office. And it has been it is a humbling experience. It brings you, even more so than presiding over litigation. Presiding over a drug court, you really direct people's day-to-day lives for a year and a half, maybe 2 years. We have currently 32 participants in the program. We have 4 phases. And we have successfully graduated maybe a couple of dozen people. Over the years, we've terminated a number of people, but it has been a terrific success.
What's the end result in your drug court? Do the people who succeed and graduate get the charges dismissed, or are they still convicted but don't have to do as much time as they might otherwise?
Our participants are 99% people on supervised release. So they've been convicted, sentenced, been in federal prison, and now have a period of time on supervised release. We have a couple of probationers who have not been to prison, but they are under sentence. And for the supervised releasees and the probationers, the condition that they participate in drug court may have been part of their original sentence. It may have been added during the course of their probation office supervision because they have such problems with addiction. And there are certain standards. We do not take sex offenders. We do not take violent criminals, people with that kind of history. But it's very hard work. And the probation officers do just a terrific job. We have a drug court team of myself. I preside over the team, but then we have 2 probation officers who are captains, so to speak. They each supervise roughly half of the participants. We have a representative of the company that provides the counseling services and other treatment services. We have up to 3 volunteer assistant federal public defenders who come, and we have, right now we have 1. Sometimes in the past we've had more than 1 assistant United States attorney participating. For an hour and a half before each weekly drug court session, we staff the people that are coming, that we expect to come to the courtroom by 9:30, and then we go and move them along. We assess them. We either have sanctions or rewards for them. We move them along or demote them from one phase to another. And ultimately, we have a happy time graduating. Our courthouse is very collegial, and we have, I don't want to say, we have a lot of parties down in the jury assembly room, and a number of them are graduations. We have 5 reentry or problem-solving courts, and everybody, sometime during the year, will have 1 or 2 graduations. That is primarily funded by the non-appropriated fund.
That's great.
And so that is a terrific thing.
So you served for a time as your district's chief magistrate judge.
Yes.
What responsibilities did you take on in that connection?
Well, it was to represent the interests of the magistrate judges to the district judges. The district judges in our court have pretty much always been accepting of the decision-making authority of the magistrate judges. We participate in governance of the district court to the extent that we're able. There are HR issues or magistrate judge issues that the district judges alone need to deal with, and we're excused from those meetings. My job was to focus the interests and to develop basically the value of the service that we provided to the district court, looking for opportunities and initiatives to help the court and bring attention to the district judges, things that they might not be aware of. I did that for 7 years, and then I was Bill Bond was the first chief magistrate. He did that for about 3 years, and then I did it for 7, and we had a change. At that time, we had a change in chief judge from Jack Nangle to Gene Hamilton. And so I decided it was time. There was no rule or regulation administering any chief magistrate judge position. And so I stepped down. Rick Buckles took over as chief magistrate judge and did a terrific job.
So you have mentioned to me that you were somehow successful in ending the CVB in your court. What does that mean, to end the CVB?
The CVB, Central Violations Bureau. That's a big name given to the administration of litigation that's initiated by federal officers writing citations for primarily violations of federal regulations, sometimes statutes, in St. Louis, and a lot of times for hunting and fishing violations, although those are primarily centered down in our southeastern division in Cape Girardeau. It's a little more of a rural area. But what would happen for decades is that there'd be we have a lot of federal facilities in St. Louis. We have a federal center. We have several VA hospitals. And we would get hundreds of parking tickets from people who were employed at these, and maybe visiting the federal centers, and patients at the VA hospitals who would be parking in the wrong places. And so any given CVB court session, we would have maybe 100 tickets that people were given, required to come to court. We would have maybe a dozen officers, federal protective officers or agency officers in court, ready to testify if people came to court to litigate their citation. We would be lucky if out of the 100 we have 5 people show up voluntarily. And so those cases would be dealt with. And then for just say 95, I would spend 5 or 6 hours reading the tickets, making a probable cause determination on the back of the ticket, signing a multi-form. This is how long ago we got rid of it. Yeah, the multi-form arrest warrants for this purpose and this person. And so at the end of 6-8 hours during the following week, we'd have a stack of arrest warrants that would go to the Marshal's Service. They would go to the Marshal's Service, and they would not be executed because of they had,
Defense nature.
exactly right. They had better things to do. Although we did have a deputy marshal who occasionally would take a handful of them, knowing that these people were employed at one of the federal centers, and he'd get a van, and he'd get a couple of other deputies, and they'd go up there, they'd park the van, and then, of course, go through the workplace arresting people to come to court because they didn't come to court the first time. That happened a couple of times. It wasn't that frequent. We just got tired of wasting that time, and so the magistrate judges suggested, and the district judges absolutely agreed, that if the United States Attorney's Office wanted to bring a petty offense or Class C, infraction, or really any kind of a case, that it would either be by a complaint, and generally they didn't, but by information. So that no more writing a ticket would get the officer into court, and that put a screaming halt to that docket. And instead, the U.S. Attorney's Office developed a very public-minded payment in lieu of appearing program with the people who did get tickets. There were tickets written, and people would receive letters from the U.S. Attorney's Office saying, you got this ticket, and this is what you're charged with, and this is what it would take to, pay in lieu of appearing. And we developed a local rule to accommodate that. And yeah.
So tell me about some of the important cases you presided over that were not Central Violation Bureau or petty offense cases.
Well, as I put on my questionnaire for the 3 applications to become an Article III judge, much the same question was asked, and I would say all of my cases are important. It's hard to separate them, and I still believe that is the case. But recently, in a high school mock trial in my courtroom, actually, the students, I didn't preside over the mock trial, but I did preside over the case of Michael Vincent. Michael Vincent was a base jumper, building, someone who would free fall and parachute from great heights. And one weekend he came to St. Louis, and he decided he was going to climb the arch and parachute off the top of the arch. And he ultimately did so. And he had talked 2 individuals into filming him as he did this. And it occurred. As I saw in the video, he free fell for a third of the way down to the ground, and then then his chute opened and he landed, and they ran away, except that they were collared and charged with trespass on the arch, on the federal property. He pled guilty. The case was assigned to me. He pled guilty. I put him on probation, and I told him part of his conditions of probation for, I've forgotten what it was, 6 months or a year, not to violate the law in doing that again. And his 2 accomplices pled not guilty. And so we had a trial, and he was called, and he testified against the 2 people he had helped, or he had talked into doing this. So they were found guilty. I put them on probation as well. And within the term of his probation, he goes to New Orleans, and he trespasses on a big building in New Orleans. And he comes back for violating his conditions of probation, and I sentenced him to 3 months in prison. He was interviewed on the Donahue show about that and had some misstatements about what actually had occurred, but he said he did his time in a very nice jail. So he had no problem with that. Yeah. I presided over the pretrial motions, and we had a big bombing gang war in St. Louis at one time. And for the first time, my face, after rendering an R&R in the case, was on the front page of the Post-Dispatch next to the headline about which was a real shock to me. I had one FBI agent walk into my office during criminal duty and say, "You're not going to believe this." Of course, it's his job to hope that I do believe what he swears is true. And he signed a complaint charging 3 people with conspiracy to hijack a nuclear submarine. And so I had a probable cause hearing on it. Ultimately, they were arrested, and NBC Nightly News sent in courtroom artists, and so we did have that. In our big school desegregation case, Chief Judge Meredith referred to me portions of that case. District Judge Bill Hungate, who I absolutely loved, he was absolutely the funniest man I've ever met, and a big personal supporter, also assigned certain responsibilities in the desegregation case.
Well, let's use that segue about how funny he is to tell us about some of the funny experiences you had as a magistrate judge.
Well, funny, memorable. I had one, and it was sort of, for me, kind of a watershed experience. I had a lawyer come in from Chicago to argue on a civil rights case. And he came in, he wore a short-sleeved shirt, he wore cut-off blue jeans and flip-flops, and he stood there and he made his argument. And I'm thinking, he's wanting me to overreact to his appearance, and I was just determined not to do that. And we didn't finish all the arguments that morning, and so they had to come back in the afternoon, and I said, "Oh, by the way," and I made a record. I just described how, from head to toe, how he was arrayed, and I said, "Mr. So-and-so, we don't necessarily have a code of dress, but what you're wearing is not appropriate, and I'll expect that when you come back to court in the afternoon, you'll be suitably attired." And he said, "Well, Judge, I'm a civil rights lawyer, and we believe that it's what's in the heart is more important than other things." And I said, "Well, that's fine, but just come back suitably dressed in the afternoon." And he did. So I kind of enjoyed that. I look back on that as, just don't overreact. Funny, I don't know, we preside over naturalization ceremonies, and I know one time I looked down, I saw a neighbor of mine from South Africa, and I looked down and waved at him. Naturalization ceremonies they're golden. They're so much fun. Trying to remember funny. I have one funny. I had to kind of intervene. It was in a civil jury trial on a Friday afternoon, getting in late afternoon, and the jury said, they're horribly deadlocked. They couldn't possibly render a verdict in this civil case. And I brought him in, and I said, "Well, I'm not going to discharge you. The parties have been here, and it's important that there be a verdict." I said, "What I'm going to do is either bring you back tomorrow morning, Saturday morning, we'll open the courthouse, or Monday morning." And with that, one of the jurors raised his hand and said, "Can we have 10 minutes? And without my saying anything, he lowered his hand, and the jury, it was like a rugby scrum. They were in the jury box. They were all putting their heads together. And I said, "Wait a second. Leave the courtroom, go back to your deliberations, and just continue your deliberations." And they did come back in a half hour with a verdict. Now, I tell my students that, and I opened the question. I didn't ask, none of the lawyers asked, even the losing lawyer didn't ask whether or not that was a coercive, was that a verdict that was coerced? And
Interesting.
Yeah, it was fun.
So tell us a little bit about your law clerks and interns. So you mentioned students, so I'm assuming you have some interns from law schools.
I have had interns from law schools all across the country. I was a law student intern when I was in school, and it was one of the best legal experiences of my life. And so at the drop of a hat, one summer I had 5 interns, and that was an intern too far, too many. But I've had 4. I participate, they enrich chambers. I'll just say that. They do good work. They do work on real cases. They do draft opinions. Now, it's obviously not going to be something that I'm going to just ultimately sign as it is in file, but they do it. They take it very seriously. I critique their work individually, and they go away. I give them a certificate that we've devised with a big seal, and they go away very happy. I have had just a series, try to make a point of, and it's usually not very hard to do, hiring law clerks who are smarter than I am, and I've been very lucky with the law clerks that I've hired. I keep them for at least 2 years, going through the selection process every year is, I look upon it as cruel and unusual punishment for a judge, for the appointing authority. So it's every 2 years. Sometimes 3, I'll offer someone to stay on for 3 or 4 years. And I've been blessed with their taking up that opportunity. But I tell them, they can be a law clerk too long before they go into the legal career outside of the court. I have, several years ago, I did hire a career law clerk. So we're entitled to one career law clerk and a term clerk. Otherwise, we'd be entitled to 2 term clerks these days. Well, I put my one law clerk as my, quote, judicial assistant. She's an expert in Social Security cases. That's one of her focuses. And she also manages chambers and the dockets and came to me with experience doing that.
So tell me just a little bit about your service to the judiciary in general.
Well, I did serve, as you have, on the criminal law committee. I've been chair of the civil jury instruction subcommittee for the district courts of the 8th Circuit for quite some time. And that has been a very satisfying thing. Early in my legal career with the court especially, I took up jury instructions as a particular interest. And so I've been doing that and for some time and have enjoyed that. But that's, in the 8th Circuit, that's labor intensive. We do a lot of work. Used to meet monthly, now it's about every 2 months, depending on the projects that we have. The inequitable pay that the federal judiciary was given over the decades really stimulated a lot of self-help, I think, on the part of the federal judges, and I participated in that. My sister's father-in-law at one time was a president of the Indiana Bar Association, and he had contacts in Congress, so we tried to favorably impress Congress with, doing right for judges pay-wise. I've been a longtime member of the Administrative Office's Federal Probation Publication Advisory Committee. Not so much active now, although I'm still on the advisory committee, but in years past it's been pretty active. We've had a number of meetings. I participated in the Criminal Law Committee for a number of for 2 terms, and totally enjoyed it. It was an honor to be selected to do that, and I can remember, I look back with mixed feelings. There was a meeting, I think it was in Fort Lauderdale, where the administrative office, God love them, thought it would be good for Congress to amend Title III of the Wiretap Act to include magistrate judges within the definition of judge, and it was close. I fronted that proposal. The committee split half and half, and so the chair of the committee Circuit Judge Mary Ann Trump Berry voted against it, and so it didn't pass. One of the missing district judges that day who came, joined the committee the next day, said that if he had been there, he would have voted for it. So, yeah.
So tell us a little bit, and we're running out short on time here, but if you could talk about your service as the 8th Circuit Director for the FMJA and other service to the Federal Magistrate Judge Association.
Well, I'm currently have been for a number of years one of the editors, not the editor-in-chief, of the Federal Courts Law Review. And one of the things I did for our federal probation was I reviewed a number of books, and they published my book reviews, which have been, I persuaded them, wasn't much of a hard sell, to allow the republication of those book reviews in the Federal Courts Law Review. So if you go, it's among the book reviews, three of them. I have an Italian cousin, his grandmother, my grandmother, were sisters, who is an Italian magistrate. And so I facilitated, as a member of the International Travel Committee, facilitated the group going to Italy and visiting with the Italian judiciary, although I wasn't able to go. I was a member of the National Council of the United States Magistrates, the predecessor to the FMJA, and I was on their Rules Committee. I began in 81. I worked with such great people, Ed Infante, John Weinberg, who is still up in the state of Washington, I think. Kent Sinclair was in New York, Art Burnett, Mike Hogan, Dick Peterson, you may remember Dick Peterson, Gene Dwyer. Ralph Gelfand was out in California. I don't know what happened with Ralph. I do remember that a number of the California retired magistrates began to mediate. They began to act as mediators without giving notice to the administrative office, and so they lost their federal judicial retirements. And very, very upset because they felt that they were blindsided. John Paul Godich is a friend of mine. He's here this week. John Roper from northern Mississippi. He was appointed in 68 or 69. The act was passed in 68. He was one of the first appointed magistrates in the country. Bob Carr from South Carolina. These were all terrific people. I have asked about Isla Jean Sensenik, who was a magistrate judge from Pittsburgh. She was sent by the federal judiciary to England to study the magistrate court program in England to provide information to Congress at the institution of the magistrate program in the United States. I should have put her name down there. She was just a delightful person.
So tell me very briefly about the debate between whether magistrate judges are Article III judges or Article I judges.
Well, I think by attrition we've won the battle. I think most of us, I haven't seen any litigation to that effect, but I think about everyone who's looked into it, I think believes that we are judicial officers of Article III courts, and happy to let that dog stay asleep. Which brings up another thing. There was a comment made either today or yesterday about administrative law judges. There was a time, decades ago, the administrative law judges were looking, many of them, of their association, offered to the district judges themselves as taking referrals, bypassing the magistrate judge thing. And as soon as that was perceived, then of course that was rebuffed pretty substantially by the magistrate judge. But that is interesting.
So as we wrap up, is there anything else you wish to tell posterity about you, yourself, or your role and service as a magistrate judge for the district court in Missouri?
In early 1980s, there was a prison riot at the Missouri State Prison in Moberly, Missouri. One of the guards was killed, and of course there was a big reaction to the riot, and there were a number of prisoner lawsuits that came out of that. There were 3 of them, actually. They were referred to me, all 3 of them. I combined all of them. I took the trial of them. There were about a dozen prisoners and 15 defendants. I took the trial to a state courthouse in the district, closer to the prison, and we began a trial on Monday, a jury trial, and we finished before the week was out. And the verdicts in all of the cases were for the defendants, the officers. But what I appreciated personally was, as one of the prisoners was being let out, one of the plaintiffs said that even though they lost, they felt they had a fair trial. And that's how I'd like to be remembered. And that's what I tell jurors when we do orient jurors, when we call them in for our civil and criminal cases. I tell them that their job as fact finders is, no matter who wins, both sides need to leave the courthouse believing that they got a fair trial. And I would like to be remembered in that fashion.
Well, thank you very much for your more than 40 years of service and for taking the time to talk to us here today.
Thank you, Frank. It's been a pleasure knowing you, and I hope we continue our friendship in the years to come. And